right before we got started, we were talking about this comment that someone left on my channel. Explicitly from my standpoint, I put out, can you just subcontract everything, government contracting? I referenced some of the rules in the FAR that's talked about similarly situated entities, and those things. But this person made a comment that says it's not true for most solicitation. They have service contracts now, pest control, limestone, they sub it all out. They work with, was put the proposal together, submit it, invoice the work. That's all they did. And they said the CORs are aware that they're the prime and who their subs are, and that what I'm saying is not true. What is your take on this?
So, generally the award from the government is to the prime, not to the subs.
Mm-hmm.
It depends upon the kind of the contract, what part of the FAR is covered. But generally, you can't sub out 100%, because even in that example you gave, he's not, or he or she is not subbing out 100%. They're still doing the administrative part. They're choosing the subcontractors, and most importantly, the prime remains on the hook. There's no privity of contract between the sub and the government. The sub can't sue. If the sub doesn't get paid, the sub can't sue the government.
Okay.
Only the prime can. So prime, in that case, the contract, they're the conduit. They're managing it, and they're collecting the invoices, and they're submitting them to the government.
Okay.
If the solicitation said you must do X and the subs must do Y, then that wouldn't work. So generally, you cannot sub out 100%.
Right.
I would say, in most cases, you can sub out parts of it, and it depends upon the solicitation. In some cases, it's in the government's best interest to allow that, because, like in that scenario, they have basically that person's acting like a project manager, administrator, and they're facilitating the work getting done by the subs for the government. But again, the invoice doesn't get paid by the sub. They have to pound sand. The only thing they can do is have the prime submit their invoices to the government for payment.
Right. Okay. So essentially, what you're saying, if I'm hearing correctly, is, hey, even though we say that you are the project manager, you're managing that project on behalf of the government. So that is the percentage of your work.
Right. And it's not just, the product management. What it also is all of the representations and certifications being made for that award. You know how a contract includes all kinds of FAR clauses.
Yes.
They're incorporated in the contract expressly or implicitly. And there's usually, dozens of them. You won't traffic in human people. You will follow DEI. You will keep your records a certain way. You will submit invoices on time. You will have an accounting system. You won't destroy records. You will, all of the various things that apply.
Okay.
Your workplace standard, whether it's Service Contract Act, the amount you pay your, all those things, the prime is certifying that they will do. So they're taking on those responsibilities too. Some of those get flowed down to the subs, and that's another obligation of the prime. They have to make sure that if this, limestone contractor is doing that, if there's clauses that need to be flowed down, they are, and if something goes awry, that prime is going to be on the hook for liability, including under the False Claims Act. Not that the prime may also be, but the sub may also be if they do something fraudulent.
Right.
The prime would be also because of the sub's unlawful activity. So they're on the hook to oversee and make sure that whatever the subs are doing, they're complying with the terms of the contract, and they're in it's much more important for them to do that than the sub.
Right. I like about what you just said. I've never heard it broken down in that way, to where you explain, like you said, all of the different aspects that you are, like you said, reps and certs that you're going to do and be responsible for is part of the overarching, responsibility of being prime.
We see a lot of cases. You have a company that primarily sells in the commercial markets, okay, a product or a service, and 97% of their business is commercial. Now, they have an opportunity to sell to the government, and they say, "Oh, great! Either I'm going to get a grant, or I'm going to sell this to the VA, or I'm going to put this on a GA schedule, or I
Okay.
signed just this one contract to provide vaccines, right? COVID vaccines to military veterans or whatever it is. Once
Okay.
you become a federal contractor, it becomes the tail wagging the dog because you're taking on all of the obligations in that contract for your entire enterprise. So your enterprise is designed to set up 98% of it is commercial that has certain business, regulatory, ethical requirements, but not as a government contractor. All of a sudden, because of this tiny little fraction of a contract that this company undertook, and this could be a multi-billion-dollar company, or it could be a small company, right?
Right.
They become a federal government contractor with all of the attendant risk, liability, certifications, responsibility, and oversight. And a lot of people, they see the dollars in their eyes when they see this opportunity, and their business person signs on the dotted line. They run into a problem, and then they call us and say, we signed this back in April. We didn't realize, and now they're questioning our compliance. What do we need to do? And we say, oh, but geez, this is, you were supposed to have all of these policies and all these procedures in place. And that's where, it's good for the lawyers, not so great for the clients.
With that, can you go ahead and tell us a little about your background, please, Larry? That's just great segue into that.
Yeah, sure. So I have been a lawyer for over 30 years. Been doing government contracts for probably about over 20 of those. I'm a partner at Winston and Strawn, which is a global law firm. I am based in DC. The firm's been around since I think 1860s, 1870s, about 150,
Wow.
60 years. Was started out of Chicago. That's still our largest office. We have few offices overseas, but essentially, I am part of a team that the government contracts team at my firm, and we represent client industries that have one thing in common: they do business with the federal or state government.
Okay.
Period.
Sure.
And so what we do for them is runs the life of the procurement cycle. We do counseling. How do you get a contract? How do you get a grant? We do compliance. How do you comply with the terms of the grant or the contract? Investigations to determine compliance or potential liability or requirement that you disclose something that you did that violated the contract to the government. Litigation, if you get sued by the government, if you get sued by a prime or a sub, someone steals your trade secrets, we do that. And then an area we really specialize in is bid protests, which is, whenever the government sets out a solicitation for a contract, whether it be for products or services, there's usually a winner or winners and a loser or losers. The winners are the awardees. The losers become the disappointed offerers or protesters. So we specialize in what's called bid protest litigation, where you're representing the companies that lost their contract, challenging the loss of that contract and saying, hey, government, you should have chosen us instead of the awardee. And here's why. And you can do that at the Government Accountability Office, an administrative, very fast-paced bid protest, which has to be resolved in 100 days. It's all on paper. There's really very, very almost no hearings. And 100 days to resolve a multi-million, multi-billion-dollar dispute is a really short amount of time. Or you can bring a bid protest in the U.S. Court of Federal Claims, and that's like more traditional federal court litigation. And if they're the winner, we represent the winners defending the award to say, hey, we think the agency did the right thing, and here's why. So we can do either side.
Okay.
And it could be any industry. It could be a defense contractor, a military contractor. It could be a janitorial services contract. It could be a contract for oil refueling. It could be a pharmaceutical contract. It could be a company selling medical devices to the VA. It could be a pharmaceutical client. It could be any, as I said, we're industry agnostic. So that's the interesting part of it, is we get to learn about a lot of different kinds of businesses where they intersect with the government.
So one of the areas that I'm interested in that I think a lot of the audience wants to hear about is you challenging unlawful grant terminations.
Yeah, doing a lot of that.
Okay. One thing that you said to me before we got on here, you said prior to January, right, your business looked a lot different than it is today.
Yeah, well, so the changes in the administration have really changed the government contract uh, practice and the entire environment. You've seen there's been sweeping executive orders. Everyone knows
Mm-hmm.
about those. You had the Doge rifts and elimination of agencies, elimination of hundreds of thousands of employees. And you've had a lot of these grant terminations. So what that's done is there's fewer staff. There's been a lot of change. So there's been a lot of delays in contract administration. Just, hey, I want my contracting officer to approve this invoice, or I want my contracting officer to approve this modification of a contract. Well, those contracting officers have been fired. They've been moved or they've been reassigned. And the person that is doing that now has too many contracts to cover. They don't have enough bandwidth and they don't have the experience. Some contracts have been moved from one agency and consolidated before the GSA, Government Services Administration. And that GSA person overseeing that contract may have no experience with something that used to be at HUD or at or at FDA. So right. A lot of change and upheaval there. And then you have different administration priorities. So in the Biden administration, there was some signature bills passed, like the Infrastructure Act, bipartisan acts, where there were certain priorities, and things were like social justice and climate change and building infrastructure and new technologies to address climate change and greenhouse reduction, and all these things were bipartisan priorities that Congress appropriated money for. We get it done, right? And then the administration changes and they say, oh, we don't like things like green technologies or social justice or DEI or whatever it is, right? And they're allowed to do that. They have, they're allowed to have different opinions or policies, but they're not allowed to remove appropriations that Congress has already made, because Congress has the power of the purse, right? Congress appropriates money, they make the laws, and they say, $100 million for a decarbonization project or something, right? And and then a grant's issued pursuant to that. Congress can't, the administration can't just cancel that grant because Congress appropriated it. They can try to limit it or de-scope it or modify it, but they can't just eliminate it. So a lot of what we've been doing in the last couple of months is representing companies challenging unlawful grant terminations.
So it's interesting. When I look, I still see a bunch of grants out here. So, I mean, people said they closed down HHS. People said they closed down FEMA. They closed down USDA. But I'm looking on here. I'm still seeing a lot of grants up there. Can you just clarify? I mean, what was canceled or dismantled? Because we hear a lot of the news.
Yeah.
And then,
So there's a lot of grants that are still out there, but ones that the administration determined did not meet its priorities, like I've been talking about.
Yep.
And, in the climate space, they terminated hundreds of grants for billions of dollars because they saw those grants as not effectuating the administration priorities. And that just means they're not fraudulent, they're not wasteful. It's just they don't agree that federal money should be spent on, and I'll make a fill in the blank.
Gotcha.
An electric battery plant, or a solar wind, or a solar project, or a wind project. Trump doesn't like those things. So they said, oh, here's hundreds of millions or billions of dollars going to these, and they characterize them as somehow disparagingly green.
Mm.
And nothing happened. Nothing changed in the program, the policy, the goal, anything. It just turned off. And so they can't Congress appropriated money for those purposes for those grants. And um, so it was unlawful. Now, if the administration wanted to follow the law, they could recommend to Congress that they enact legislation to, in future years. Let's say the grant was over many years, to change that. They could do that, but that takes a legislative vote. It's not for the executive to decide. So yes, there's still many grants out there. That's not a surprise. There's billions of grants at various agencies, but billions of dollars of grants since January have been terminated.
Okay.
And they're usually terminated, Eric, in big groups. So there's 50 grants, let's say, of multi-billion dollars to go to a green project. They terminated on the same day, all 50 grants, saying none of these grants effectuate. It's not like they're doing a finding of wrongdoing for any particular grant. They're just in mass terminating them. And that's why so many different, or there's been so many different lawsuits in the U.S. district courts challenging these terminations as unlawful.
No, I see here where it says 2,100 NIH grants were terminated. I also see a list of HHS grants here that were terminated. I mean, pages and pages, 73 pages of it.
Yeah, again, that's somebody from Doge or somebody from an agency or the administration saying there's groupings of these grants that we don't like for political reasons. We disagree with almost, in a lot of sense, grants initiated during the last Biden administration for political reasons, and then just terminating them.
Wow. So let me ask you this. So going through, the GAO process, it looks like somewhere in the neighborhood, again, my research could be wrong, it says about 16% of bid protests reviewed have been relatively flat. I mean, is that accurate? About 16% of the bid protests that have been reviewed, that they sustained them. Is that that's what I saw numbers wise, but what kind of chances am I taking by going after these, trying to actually challenge the government?
So the statistics on challenging GAO decisions are misleading to the uninformed reader.
Okay.
And here's why. It's actually a much higher success rate. So when you challenge an award at the GAO, you challenge it on one or more grounds. And what happens is fairly quickly, the agency responds to that with either we're going to fight it and we think that we did the right thing and the protest has no merit, or, the protester identified something we did wrong and they take corrective action. And corrective action means they're going to change something in the solicitation or in their evaluation or in their award decision, or they're going to do a new evaluation to try to get it right in conformance with the errors that the protester identified. We consider that a win because that's the relief you wanted. You want them to revisit and say, hey, you unfairly considered Eric's company, you should have considered ours. That's a win. So those don't get counted in that sustain. A sustain at the GAO is only after a decision on the merits where the GAO agrees. But many, many more of the protests are won, in air quotes, because the agency voluntarily agrees basically to revisit, reevaluate, or sometimes do an entire new procurement based upon the strength of the protesters' arguments. And we have had great success, much higher than what is typically stated.
It's funny. I've seen that before, and so I know exactly what you're saying. I was part of an IDIQ where they initially a second batch of winners after the fact. So I see how that makes sense. Thank you for clarifying that.
As long as we can fight to live to fight another day,
Right.
In other words, you're staying in the game. That's a win on a protest because you haven't been ruled out yet. Now, you still may not get the award, right, after a
Sure.
corrective action, but at least you're guaranteed that it was a more transparent and a fair process. And if your price was too high, you can learn from that for the next time and maybe give a better proposal next time, and more competitive proposal. But at least it's a fair basis, not a disparate treatment or unequal treatment by the agency.
No, that makes a lot of sense. Can you talk a little about the Contract Disputes Act and what does that even mean?
So another thing that we do that I didn't mention before, I mentioned protest litigation, but is claims litigation. What's a claim? A claim is like it's a certain term of art. When you have a contract, so you're already a contractor now, you won your award, and you're performing, and you're owed money from the government. If the government doesn't pay you what you're owed, or you disagree with the amount, or you disagree with the costs that are allowable for you to recover, you have a dispute. You raise that dispute in writing to the contracting officer, and that contracting officer says, "You're right, here's your money." They say, "You're wrong, you're only entitled to 80% of what you claim," or "You're crazy, you're not getting any of this," denied. In any of the latter two scenarios, where it's less than you think you're owed or it's denied, you get a final decision from the contracting officer saying, only 80% or not at all. That becomes a claim as defined in the Contract Disputes Act, which is a statute that allows government contractors to sue the federal government either in the U.S. Court of Federal Claims or at one of the boards of contract appeals, either the Civilian Board of Contract Appeals or the Armed Services Board of Contract Appeals if it's a defense contract, for that claim. And what you do is it's essentially a lawsuit for the money owed, but there's a record for the court to review. The record is, here's what I'm owed, agency, and the agency saying, no, you're not, and here's why. And then that record then becomes a formal claim that you litigate in one of those, in either the court or the board. And the government has waived sovereign immunity for that. In other words, not all countries around the world, if you have a contract with the government, can you sue for that? Right. In this country, the government has agreed to waive sovereign immunity where you have a claim, but only if you've reduced it to a formal claim. There's a process you need to follow. Mm-hmm. And if you do that, the government says that this Contract Disputes Act says you have jurisdiction in one of these two places to sue the government for money damages for those amounts. That's what it is. Okay.
And when people do that, are there statistics around the probability of success with that? I mean, is it 60%, 50% success?
Yeah, I haven't seen statistics on that because each claim is so different based upon, the facts, the circumstances, the decision maker, the judge. Right. What is a win if you get 60% and they said 50? It's very subjective to determine what a win is. Okay. But you have to assert the claim or you waive it. So you can't later then say, the end of the project 2 years later, right. Oh, you owed me this. And no, you had to timely submit your claim. You didn't. No jurisdiction. You're flat out of luck. So you need to timely submit a claim. You have to certify it. The company needs to sign it. There's a level of verification and proof that goes into it because, you're asking for money from the U.S. Treasury.
Is there a recent case, or whether it's one of your firm or public record, in terms of a large dollar judgment or settlement that someone could reference that you know of?
In what context? I mean,
in terms of this type of suing the government for contract disputes.
Oh, a claim. Yes.
Yeah, like is there a public case that, hey, this company sued the government, HHS, they won $22 million, right? Because they were, I don't know, the government didn't pay them because they discovered, damaged soil. and they had to
I can't cite a recent case, from by name, but I can tell
no,
you
no, no, not name, but just
every day,
record.
all the time. Yes, all the time.
Really?
Yes, it's very common because by the time usually the claims get resolved at the contracting officer level. That's the key.
Mm,
You have to file the claim first. By the time a company decides that it's worth it to go to court, they usually have a pretty strong case.
I
And,
got you.
and so by the time it gets litigated and the government's willing to defend itself, it's usually a pretty big claim. And these claims are in the millions, tens, hundreds of millions, billions of dollars sometimes. So while you can go for lower amounts because of the cost of litigation, a lot of times companies won't bother. But if it's large enough to withstand, to justify hiring a lawyer and going to the court or the board, then oftentimes I think there is a good chance for success.
Okay, that makes sense. You mentioned the clawing back of contracts or terminations for grants. What are some of the programs or agencies that have been impacted the most? I know you mentioned energy. What are some of the other programs?
It came in different waves since January. The first wave was USAID. So all grants, virtually almost all grants with USAID were terminated because the administration attempted to dismantle and close down all of the USAID programs. So by definition, the grants under those programs were terminated at the same time. And then several lawsuits were immediately filed. And for international aid for food and welfare and social causes around the world, those were just wholesale terminated. NIH, as you mentioned, a lot of NIH grants that the administration didn't like were terminated. Department of Energy grants were terminated because the ones that were either seen as green or climate friendly. EPA environmental grants were terminated because the administration said they didn't align with their priorities. Grants for social justice, so training programs to provide legal support. Grants in the health space where for training for things like women's care, health care, anything related to abortion services, education, grants in the legal justice training for things like the death penalty, training for lawyers to teach lawyers how to educate practitioners who do pro bono work to defend people on death row. Those were terminated. Let's see, Department of Education grants, because like USAID, the administration has tried to basically close down the DOE, Department of Education. So grants in that space have been wholesale terminated. So billions and billions of dollars across HUD grants, housing grants that they didn't like. And then any grant that had a part of it that was tied to diversity, equity, inclusion, they were all terminated as well. Whether that was all of the grant or some of the grant, or the grant was terminated because it included some sort of DEI component.
No, we've heard about USAID. I know a lot of people heard about them. That was a big one, right? I've heard things about FEMA. What have you heard about FEMA or seen?
Yeah, FEMA is another agency. The administration it's just, look, we're just talking about this just to try to identify the agencies. I didn't even mention FEMA. FEMA is another one where they're trying to dismantle it. Right. And so if you've got a grant services and the administration doesn't like that program, they've tried to terminate the program, which then terminates the grant. Yes. And so in a lot of these cases, the administration is trying to turn from a federal obligation to do this kind of service or work to a state, and in many cases before the state has even voluntarily accepted the burden of the obligation. So FEMA is an example where they say, oh, okay, the federal government now provides, make it up, water and housing for people that are displaced by a natural disaster. Now the proposition is, well, I don't like this $400 million grant that goes for that. Now it's going to go to the state. So if it's Alabama and there's a tornado there, the state will have to pay for it. Well, first of all, does the state have funding for it? Who knows? Does the state have a grant for that? Who knows? Do they have sufficient supply? So FEMA has been set up for decades, to do this kind of work with the expertise to try to do it in an efficient and expeditious manner. Now, is Alabama, for example, equipped to do that as quickly? For them? Who knows? There haven't been studies done to do that. There wasn't congressional oversight to determine whether or not that was appropriate. It was just done. And so I think a lot of the legal issues people have is ultimately, even whether or not the executive could do these things, it wasn't done in the right way, with the right oversight, with the right notice and process, where you have a reasoned analytical basis for doing some of these things. It's just, we don't like it, we're going to end it.
I'd like to talk about the False Claims Act a little bit, right? Can you first just give us a definition for those to bring us up to speed on it, what the False Claims Act is?
So, False Claims Act is very old. It's been around since the Civil War. It was passed during the Civil War to prevent fraud on the Union Army and the government for people like that didn't work, or tents that had holes in them, or military supplies that were substandard, because the Union had to buy a lot of stuff very fast to all of a sudden amass this federal army for the first time to fight the seceding states, right? So the False Claims Act was passed in that time. Since then, a few hundred years later, it's evolved to prevent a government contractor from receiving money at the same time as they're submitting a claim for that money, reimbursement, while doing something unlawful or fraudulent or that the government doesn't know about, at the same time that they're getting that money. And I say that it doesn't have to necessarily relate to the claim for payment. It's just while the two things are going on. So your company's receiving federal funds on the one hand, and the other hand, you're doing something that violates terms of a statute, the terms of a grant, the terms of a contract, the terms of a regulation that is material. And if the government can prove that, it enables the government or a relator, that's a plaintiff, I'll explain that in a second, to recover money damages under the Civil False Claims Act, and treble damages, 3 times damages. So let's say you received $100,000 under your invoice, and it determined that you'd said something unlawful about the quality of the product or the process that you were providing. And had the government known that, they wouldn't have purchased it, right? That the plaintiff in the False Claims Act case, in that case, would get $100,000 back times 3, so $300,000 plus penalties, all for that one invoice. Now, you submitted 100 or 1,000 or 10,000 of those invoices, you could see it quickly escalates into big leverage of millions or billions of dollars of claims. Now, I mentioned a relator is the False Claims Act enables private citizens who uncover the fraud, they're called whistleblowers or relators. They can bring a False Claims Act themselves. The government has the right to intervene and become the named plaintiff in a case, but the government doesn't have to initiate it. So you're working at a company, you see that something's going awry, you raise it to management, management says, be quiet, we're doing the right thing. You can then hire a lawyer, file a False Claims Act saying, hey, these invoices they were violated the False Claims Act because I know from my experience they were violating this rule, regulation, or contract, right? If you prevail, you as that private citizen get a significant portion of that recovery. So it provides a financial incentive to be a whistleblower, because if you uncover this fraud and you prevail, you can get sizable damages recoveries. And the government gets the money back as well.
So let me ask you a question, because I've had people on my show, we talk about certified payroll, right, and the Davis-Bacon wages. So would someone not conforming to the Davis-Bacon wage, would that be considered something
It would.
Okay. Yeah, because people on my show said, hey,
that's an example of violating the Service Contract Act or Davis-Bacon, or like domestic preferences, the Buy American Act. Oh, I know that they bought these products from China or, from another country that's not permitted. Those kinds of things all the time. The country of origin. We built and sold these components to the government. The company represented they were made in America, but 40% of them was made in China, and then they and repurposed. And so like all of those invoices that were submitted, the government paid for all of those products. Those are all fraudulent. Like, those are the kinds of things.
Yeah.
So we, as a law firm, we do investigations of False Claims Act allegations all the time and determine whether they have merit and whether they need to be voluntarily disclosed to the government, or whether we fight them in a defense of a false claims action in court.
I want to close out something that we brought up earlier. You talked about the executive orders, right, and some of the memos that go out. I mean, are agencies supposed to be following these executive orders? I mean, are we as contractors supposed to follow them? Like, how do we know what? Like, what should I, if I'm doing a contract and there's an executive order, do I tell the contract office, hey, this executive order says do this, and you're not doing it? I mean, what do I like?
Great question. And it's created such uncertainty. And the government contract market, like other businesses, they like certainty and stability. So these EOs have created great instability, uncertainty, because just like your question, people don't know what to do. So an EO, an executive order itself, is really not enforceable law. It's just a pronouncement for the president. Hey, agencies, here's what I proclaimed I want you to do. I am the chief of the executive, right? But then the agency has to take that executive order and implement it in some sort of agency directive instruction saying, hey, you contract or a grant X. Pursuant to the executive order, we have determined that you must do Y. If you don't do Y, we will terminate or otherwise, cancel part of or all of your grant or your contract. That's how it becomes. And then sometimes that will get codified into some other directive or order from the agency or from the contracting officer, and then you have to follow it, right? Or they'll modify the contract, Eric, to incorporate that thing in the EO. So in a case where it's a unilateral modification, the contracting officer says, pursuant to the EO and the agency directive and this guidance, we are hereby modifying your contract. You must comply. And if you don't, then they terminate because you didn't follow the terms of the modified contract. So that's the way it works. And that takes some time to do. But the EO itself just said everybody's scrambling. Oh, I have to get rid of all my DEI policies.
Right.
Illegal DEI. Well, it was never defined. No one even knows what that is. It's never been defined by the administration. What is illegal DEI? What's illegal about it? What's illegal? Is it the diversity? Is it the equity? Is it the inclusion part? Is it all three? What is it? So the only thing that the Supreme Court has determined was unlawful was an affirmative action program in higher education in one case. That's it. And the administration basically took that and tried to leverage it to say, we know it when we see it. We don't like illegal DEI without ever defining it. So companies are left to decide, do I dismantle my DEI program? Do I change the wording? Do I eliminate certain factors for hiring, recruiting, promoting? No one knows what to do. It's always been unlawful to discriminate. But the difference here, Eric, is the administration has said, we think that DEI itself discriminates. You're not allowed to have preferences. You're not allowed to have programs to encourage certain sectors of historically disadvantaged populations getting any advantages in hiring, firing, or retention. And that hasn't been litigated. It's just been proclaimed.
So what do we do?
Everyone has to make a decision about the risk tolerance. So many companies are fighting it. There's 250 lawsuits or more challenging administration actions pending right now in federal district courts. 250 over all of these programs and decisions and EOs and things we've been talking about. Many of them relate to things like DEI, and it hasn't bubbled up to the Supreme Court yet. It's some of them are bubbling up to the appellate courts, the circuit courts, but by and large, most of the courts that have reviewed the DEI related things have held them unlawful and have said, you haven't defined what illegal DEI, and how can you determine that this is illegal DEI if you haven't even defined what illegal DEI is?
Wow, you said 250 actions?
Yeah, there's over 250 actions pending against the administration for all of this January 20 activity we've been talking about across all of the different agencies.
Wow. What's the best way to reach out to you? I see your LinkedIn profile, but I assume there's probably a better way to reach you.
I mean, by email. We're on the Winston website.
Okay.
And so you can reach out to me there. And so again, a very simple question for a prospective client is, do you do business with the state or federal government? We haven't even talked about states, but states have very similar procurement issues and similar procurements, and some of them are very large. Just because it's a state-run procurement doesn't mean it's large. A contract for bulletproof vests by a county can be a multi-million-dollar contract, right? A contract for administering the food services at a prison, for a state prison, that's a big contract. So state contracts can be very large. There's state-level bid protests. Health, Medicaid are state procurements. We do those in various states. The Medicaid contracts to health insurers, where they compete to be one of the contractors that administers the Medicaid program for a given state. So state-level procurements are very large and very complicated, and each state's a little bit different, and different laws and different rules and different case law. So you do need counsel to help you when you're fighting those kinds of decisions as well.
You said people come to you after we get in trouble. When should we come?
Beforehand, before you sign that grant, please come before.
That's your. You're gonna put on a billboard. Please come before you sign. Before you get. Okay, come before you sign. We're gonna leave it at that. Right, Larry, I appreciate you. Thank you, man. I appreciate you, brother. Thanks for coming on today.